Hello, everyone. Welcome to one more edition of the Arbitech chapter of the Arbitration channel. And tonight, I have the pleasure to have here Pablo Palazzi, a tier one technology lawyer in Argentina and a friend as well. We talk about developments in technology, the regulatory framework of technology in Argentina. It will be a very interesting conversation since a lot has been changing the past months, past years in Argentina in this subject. So there is nobody better than Pablo to talk about that and share his thoughts on all this innovation and all these developments. So Pablo, for those who don't know you, can you please present yourself?
Yes, thank you, Daniel, for the invitation. I'm Pablo Palazzi. I am a partner at Allende Ambrea, which is one of the biggest law firms in Argentina in the tech department. And I'm also a law professor at San Andres University in Buenos Aires, Argentina.
Okay, perfect, Pablo. Again, you are very welcome here. So to start, Argentina, for instance, published a data protection law almost a decade ago, right? Way before Brazil.
More than a decade, 24 years ago.
24 years.
2000.
We had our data protection law. Our first data protection law was published 6 years ago. So yeah, you're way behind Argentina in that subject. So how was this preparation? Because it was another moment of technology. So we were just beginning to deal with the .coms. We didn't have social networks, social media.
Okay, that's a good question. I mean, this is good and bad. It's good that we have 24 years of experience in data privacy because we were the second country in Latin America after Chile to enact a data protection law. But Argentine law was the first country to be recognized as adequate by the European Commission. And the law at that time was good. Now, as you said, it's kind of old, 24 years. And even though we have a lot of experience because we have court cases, a DPA that has been active in some moments and has issued a lot of guidelines, we still living with a first generation law, and it's very difficult to apply it in practice because, as you may notice, Brazil has a second generation law like Ecuador or Chile now, and those laws has better regulation in terms of legal basis, DPO, privacy by design, etc. So we have an old law, and the disadvantage is that the law is becoming older and older, and in this age of artificial intelligence, we need to urgently change it a bit because it's.
So how is this discussion right now? How far is that discussion?
I mean, it's moving, and I think it's paused. There's a pause because of economic changes that we are going to talk later in this conversation. But the government last year prepared a bill that was drafted with participation of technology sector, academia, NGOs, etc. There were several months of public discussion, and then the bill was sent to Congress. They have a couple of meetings in Congress, but because of the presidential elections and the change of government, it was paused because the current Congress is discussing economic reforms bills, which seems to be more important or more needed at this time. So we expect that the data protection law will be discussed probably next year.
Okay. So dealing with technology, you have this like kind of old data privacy regulation. I know that also Argentina is discussing an AI bill as well.
Yeah.
And I know as well that the banking regulation, the cryptocurrency regulation is also very established in Argentina, right?
Yeah, crypto is booming in Argentina because, as you know, we always have economic problems in Argentina, and because of that, citizens are not allowed to buy dollars on banks. So they either have to go to informal places to buy it, or they can buy crypto. And because the central bank has this theory that crypto is not currency, they cannot regulate crypto. So because they cannot regulate crypto itself as money, they can create other things, but they cannot touch crypto. So crypto has been booming in the sense that you are allowed to buy crypto, and they cannot forbid you to buy crypto. They can forbid you to buy crypto through banks. So there was this bank called Banco de Galicia that tried to offer their clients the chance to buy in crypto, and they were all need to do it for a morning for 3 hours. Then the central bank say, no, you're a bank, you cannot allow people to buy crypto. So they have to cancel the project. So that was the short life of crypto related to banks. But we have exchange and we have wallets, and they are operating. And the only regulation that they have is that because of money laundering concerns that is happening all around the world, Gafi came here in Argentina at the beginning of the year, and they forced Argentina to enact a regulation for crypto money laundering, which basically created a registry at the SEC of Argentina. It's called Comisión Nacional de Valores, which is the stock exchange regulation, and they created this registry for PSP and exchange operating with crypto, where they need to register if they operate in Argentina, and that's it. It's only a declaration for purpose of money laundering, but then there's no additional regulation. So it's kind of free now, and as an example of that, I can tell you what happened at the beginning of the year with a project we did with crypto and a client that wanted to create a new corporation in Argentina to operate, and they wanted to have the capital of the corporation expressed in crypto. So to do that, they opened two wallets, a wallet in Lemon for the partner, and a wallet for the two partners, and a wallet in Ripio for the corporation to be created. They transfer the money that was going to be the capital, which was a couple of Bitcoins and USDT, and that was sent to the account of the company information, and then we filed the papers at the Register of Corporations, and the Register of Corporations with the new government was very pro crypto and pro business, and they accepted the creation of a Sociedad de Responsabilidad Limitada, which is a SRL, with crypto. And a part of that, they created a regulation specifically to create to incorporate with crypto. And this was Resolution 16, and now you can use crypto to create a corporation in Argentina. And this was unique in Latin America. It was the first case I think in the world. In the world, there was a case in Spain, like 15 years ago, and this is the second case.
Oh, amazing. And as you said, it was probably due to this new economic and political moment in Argentina, right?
Yeah, I think yes, because Argentina has like a history of embracing startups. We have like Derremate, Mercado Libre, Globant, OLX. Like, we have a lot of unicorns that were created by Argentine entrepreneurs. So we have a very, very nice environment on that. Sometimes they don't thrill because of economic problems, but when you let them advance, they create a lot of new things. And apart from that, take into account that we have a digital signature law from the year 2000. So we've been using digital signatures and electronic signatures since 24 years ago. We have a computer crimes law, and Argentina is also a member of two treaties, the Convention of Europe, Convention 108 Plus, which is the data protection treaty, and the cybercrime convention or Budapest Convention, which is the computer crimes treaty. So we always keep updated on terms of technology and regulation.
That's interesting data that you brought, because it leads us to the next topic that I want to talk with you. Because I've been following and watching the developments in Argentina, of course, and as an outsider, that Argentina is now trying and moving forward to be a low regulation hub, and I think it's sort of the opposite that's happening right now in Brazil. I've been a harsh critic of our DSA. Brazil tried to publish a DSA, which was called like the Bill of Fake News, because it was full of articles that hadn't do anything with digital services in the end. And thanks God, this bill was discarded. And right now we are discussing, as in Argentina, as like in whole Latin America, a bill to regulate AI. And I was talking with friends from Colombia, and Colombia was like really close to publish an AI regulation, but they stepped back in order to build another law that was like more soft and not as harsh as the EU AI Act. So I'd like to hear your opinion on that and how the Brussels effect, how Argentina may be immune now to this Brussels effect. And yeah, I'd love to hear your opinion.
That's a good question, and take us to a lot of issues. There are like 30 bills in the Congress about regulating AI of all aspects.
30?
So, yeah, like 30 different bills. I can send you a list. Like we have checked all of them, but they're bills only. They're done on laws. And already President Milei has expressed concern about regulating AI and innovation. And as you can see, he's a very strong supporter of technology and economic regulation, and not economic regulation in the sense of liberating the economy, not in the sense of creating obstacles to development of economy. So most of the laws that he has been enacted are laws that create freedom to operate to companies. And as an example, the first bill that he introduced, that was not approved because it was too long and has a lot of things. It was very ambitious. That was introduced in January or December, I think December, and it has a chapter for autonomous vehicles and self-driving vehicles. And it was a primary in Argentina because no one has talked about that before. That bill was not approved, but then he negotiated with Congress a second bill, which I'm going to talk a bit about more, to promote investment. But he's an admirer of Elon Musk, and he visited him twice already in his 9 months of governance. And it's just the opposite to Brazil, that the Twitter versus Brazil controversy.
Yes.
And so it's just
there was a new one yesterday.
Oh, I didn't know that.
Yeah.
What? Wow.
Yeah, the how do I say that in English? But the wife of the president,
Yes.
said, "You, Elon Musk." So
Okay.
yeah,
Okay. Well, no. It's good to put the contracts because Argentine's regulation is pro. Starlink, for example, started operating in Argentina the following day that Milei was president. So it's everywhere Starlink now, and it's a clear. This government is clearly favoring technology and the development of technology, and I believe that they may veto any law that tries to regulate AI. So they will not allow to enact a law regulating AI.
no, yeah. I think now Brazil and Argentina are living very different political moments on this, especially on this approach to regulation, to the economic regulation, but especially technology regulation. But as in Brazil, as in Argentina, you have to. It doesn't matter the president; you have to deal with the Congress, and by the end of the day, is the Congress that has all the cards. So uh, we can tell, as I said, this bill, fake news bill, or the Brazilian Digital Services Act, was discarded after a long political fight, and I believe that the Artificial Intelligence Act, it was supposed to be published like a year ago, and I didn't see in the future how it will be approved in any time, at least in the near future. Right now in Brazil, we are discussing a very important article of the Internet Civil Framework. That is the article that creates immunity to platforms when we are talking about the content that is published on them. So right now they are only liable if they do not remove the content after a court order. So
Okay.
of course there are exceptions such as IP rights and pornography.
Revenge porn. Revenge
But
porn.
sorry.
Revenge porn also, I
Yeah,
think.
yeah, revenge porn, exactly. Yeah, but the Brazilian law that's from the 2014, this Internet Civil Framework, the whole idea is based on the freedom of speech and the impossibility of a previous censorship. So right now, the Supreme Court is going to vote the constitutionality of this article after 10 years.
Wow, very interesting.
Yeah, and we are living like this is the complicated moment that internet is living in Brazil. So talking about that, we what do you follow, and what are your opinion and your feelings on disputes involving technology innovation? How are these developing in Argentina? How is the case law in court in Argentina? Are they prepared to receive these disputes? Is arbitration a thing when you're talking about disputes involving technology companies?
Yeah, I can list you what are the issues, a topic that has been discussed in Argentina, and then I can talk a bit about arbitration in
Of
light
course.
of the economic reforms of President Milei. But the probably the most litigated issue in Argentina in the past 10 years was the controversy about ISP liability, internet liability, the one you were mentioning about Marco Civil de Interneti.
Okay.
And we have a similar legal structure. In theory, you're not liable and you don't have to remove content unless you have a court order. That creates a buffer zone, a protected speech zone, where the internet intermediary, let's say a social network, a search engine, whatever, Twitter, etc., will have to remove content only if there's a court order. And this is a final court order or an injunction, probably. But before that, you're not supposed to take action unless it's pretty obvious that there's something illegal. And there's a list of things that are considered illegal, which can be discussed and debated. But most of the cases, you need to wait for the court order, which is good for freedom of expression, but is bad for right of personhood or right of personality and privacy and IP rights. So, but that was a kind of legal case law recognition of something like the CDA in the US, like the CDA Section 230. So that took like around 10 years to reach the Supreme Court, and the Supreme Court, in the case Belén Rodríguez versus Google, Belén Rodríguez was a model, said that you have to wait for a court order and you're not liable until there's a court order saying remove this. This is illegal. But if there's a declaration of a court saying that this is illegal, you don't have to remove it. And that's good for businesses and technology companies. It's not good, as I said, for the rights of people, but it's a way of seeing freedom of speech and protecting the internet. And the second stage was the right to be forgotten, which was litigated in a case involving a model that was linked to Maradona in the drug case that he had 20 years ago. And she said she revealed her life and went to live to Miami and become a journalist, and she was received a Grammy Award, etc. And she wanted to clean her searches from her past, and the Supreme Court said no, that you are a celebrity, a very well-known person, and you don't have the right to be forgotten. They didn't close the door, the Supreme Court, but basically with that case and with such strong opinions, it will be difficult to win a case for the right to be forgotten in Argentina. So those are the issue about internet liability. The second way of litigation is related to cryptocurrency, and there are cases dealing with money laundering and crypto. And there was a case called Bobinas Blancas, which basically they were using crypto to money laundering, and they were sentenced to jail. There's another case about consumer protection. There was a consumer that made a mistake when he wanted to transfer a lot of Ethereum to another account, and he made a typo, and the Ethereum disappeared, and he lost a lot of money. So he sued the exchange, which was an exchange from Chile, but he sued in Argentina. And contrary to all expectations, the Commercial Court of Appeal said that you were trading in crypto and you have done a lot of transactions and you were a professional and not a simple consumer. So it's your problem if you make a typo and you send the Ethereum to the wrong address. So you have to be careful. And the argument was that the exchange didn't have a QR code that allow you to copy the address without typing each letter and symbol. And they said, no, consumer protection does not apply here. It's totally contrary to a lot of other cases of fraud against banks. During COVID, we have a lot of cases against old people that were defrauded and lost all the money because you were recluded in your home and connected through the internet, and someone will enter and hack your account and take out money. And those cases are all in favor of consumers and against banks because they said that when a consumer connects to the internet and does a transaction, and there are people they don't know very well how to do it, and they are a protected class. So most cases of fraud online are in favor of consumer in Argentina. Then we have a couple of cases related to data breach litigation. Data breach is a high list issue here in Argentina. The government has like 50 important cases of data breaches. They basically, hackers have stolen everything from each agency, national agency in Argentina. Immigration agency, the national document registry, the license driving license registries, everything. Everything is online. You can buy it. You can find it in Telegram channels. The government looks to their side. They don't recognize anything. They said, this is not happening. Everything is secure, but I've seen it myself, and it's on the newspapers. And then companies are breached also. So there's a couple of supermarkets that has been breached, and they were fined by the DPF Argentina, and there are a couple of class actions against them. Then there's a company called IFX Network
but just one question, Pablo. These litigation related to data breaches, they are administrative proceedings instituted by the DPA, but do you have also like consumer claims, class actions?
Okay. Yeah, the DPA has put a couple of fines against companies that has either not notified the data breach or have a data breach which is serious and have not informed the DPA or took measures to avoid a future data breach. So when you have a data breach, you need to block the holes, let's say, or the gaps, or just call someone in cybersecurity and say, why this happened? Because this or this or this. Okay, I fixed this. It's not going to happen again on this side. You know that there's always a chance that you will be hacked again on another way, but you need to work on fix it and show the DPA that you work on fix it. If you don't do that, probably you will be fine. And after the fines took place, the DPA published the fines, and a couple of consumer organizations file class actions based on the DPA fine. And basically, in tort law, when you have to prove that there was an illegal act, and because you have a fine from the DPA, you already proved that there was a breach of the Data Protection Act. So half of the way is done when you have a DPA fine because the DPA has done the work for you. So it's more like a trip field for the consumer section. So we don't have a decision yet in those two cases, one from Córdoba, one from Buenos Aires, but we'll see. Probably there's going to be a decision imposing damages.
Interesting.
Yeah. And then we have individual cases like the IFX case. IFX was a provider of cloud computing for the government and for companies, and they have a huge attack, data breach and malware attack during the beginning of the year. And they provide services to the government of Chile, Argentina, and Colombia. And because of that, the judiciary power of Colombia stopped working because they have to close for one week or 2 weeks the system. So basically, in Colombia, if you were a lawyer, you couldn't file an online case or because everything was closed. In fact, the DPA of Colombia used EFX also, so the DPA of Colombia was not working for a while because of this. The situation was
SIC, right? The SIC.
The SIC published a recommendation, and even the president of Colombia said something bad about this company. In Chile, the national purchase system for the government, where you can buy things for the government and sell things to the government, was closed for 2 weeks also because of this. Some municipalities in Argentina stopped working, and there's litigation against this company for the data breach in several countries, including Argentina, which is an issue because it's very difficult to measure your damage. If you're a company and you stop working for 1 month or 2 months, for example, how do you measure your damage? You have to hire someone to restart all the systems. You stop working, you stop selling. It's very difficult to give an amount to the court of damages. So maybe you have to calculate the money you spend going back to the original situation plus the damage for not operating, which is money losses, the money you lost for not buying or selling or whatever you are supposed to do. But it's complicated. There's no formula yet in Argentina, probably in Latin America, to determine the damage amount.
It's very hard. There is a colleague of mine that was in an event in Asunción a month ago, and I was discussing with her this difficulty to quantify damages when you're dealing with digital assets of any type. And also, I think one of the, not only quantifying the damages, but also the burden of proof. Since, as you said, like a lot of data has been leaked in the past, I mean, like since the internet was created, and how can you link that information was leaked from that database? So it's and of course you have to in Brazil, and I believe in Argentina as well, the consumer, the natural person, he has some benefits that the law grants them, but in the other hand, it's very hard for the companies to deal with this overturn of the burden of proof.
Yeah, it's complicated, and this new technology litigation is new, and we don't know what's going to happen. It happened also. Another trend in Argentina is there are a lot of companies lending money online. So if you need money, you can go online with 2 clicks, and you have money in your account in seconds. But then some people don't pay back the company, the lending company. They are not banks; they are non-financial companies. They are long list in Argentina, and then they want to foreclose or go after the consumer, getting back the credit, the payment. But there has been a discussion whether this is a loan that has electronic signature or digital signature. So a lot of cases are discussing online whether there is a loan agreement just by clicking, putting a click online. And at the beginning, they rejected the theory, but then after COVID, they start changing, and courts are saying, well, there's a click, and click is an expression of willingness of getting the money, and they receive the money. So this is a loan, and this is a digital or electronic signature, and there's already 2 books dealing with this, and a lot of cases. And cases are shifting from no signature to this is an electronic signature, and this is a valid contract. So that's another trend important in Argentina.
Yeah, we had the Superior Court of Justice in Brazil had a decision dealing with that, whether the digital signature was effective enough for a contract to be valid and especially to be enforceable.
Very interesting.
And it was like crazy because a lot of financial institutions and non-financial institutions that provided payment service were doing that. There was like a huge legal uncertainty. What would happen? Because imagine this, what would happen in the spread?
Yeah. Oh, interesting.
Yeah, it was fortunate that the Superior Court of Justice decided in this way. And I also, still talking about litigation, are there specialized justice or specialized courts in technology in Argentina?
No. I wish we have. There's no. So basically, your case can end up in commercial court, civil court, criminal court, and what we have are computer crimes prosecutors. There's a couple in each province and one at the federal level. So because they are specialized they understand the evidence, they know how to collect correctly the evidence. So in criminal cases, we are seeing a very, very good development of cases where the chain of custody of evidence, evidence in certain fraud cases or pornography cases or revenge porn cases is being litigated correctly because the prosecutors are very well prepared to deal with this, and they what they do basically is that they start the collection of evidence very soon when the case starts, and after that they send the case to the judge already with all evidence collected. That's one of the advantages of having special prosecutors in criminal and computer crimes law. And we may have like 6 or 7 provinces already with computer crimes prosecutors offices, like Salta, La Rioja, Córdoba, Buenos Aires, Chubut, and the national level. So that's creating a very, very good environment for litigating cases with good evidence.
No, interesting, interesting.
And another trend is whether the local company of a technology platform has to respond or answer on behalf of the foreign company. Because sometimes we've seen that the local lawyer is a bit lazy and doesn't want to go through the letter regulatory or the Hague Convention to US, and instead of suing the foreign company, they sue the local company of Google, TikTok, Meta, etc. And that discussion led to saying whether they need to answer on behalf of the foreign company. And the Attorney General, in 3 cases that are in Supreme Court, said that yes, you can go after the local company for the foreign company. That hasn't been decided yet. And there was a change in the law for cases of revenge porn. You know that Olympia Corral was a victim of revenge porn in Mexico, and she's a campaigner. And she came to Argentina, and Congress enacted a law called Ley Olympia, which is a law to prevent attack on women on digital environments. And one of the things that the law made was an amendment of the corporation law that forced local companies or foreign companies to be notified of internet infringement. So that's only for revenge porn cases, no?
Yeah, we have in Brazil what we call the appearance theory for consumer cases
Okay.
that deals with that. If you have a problem, for instance, with Philips,
Yeah.
US, you can file a lawsuit against Philips Brazil.
Okay.
So yeah, it's
Oh,
in,
interesting.
in that and that works. We had also a problem that with this issue, they need to have a legal representative in Brazil for some companies. That's how started the beef between Alexandre de Moraes,
Yeah.
our justice, and Elon Musk because of the X. So it started with the need to have or not a legal representative on behalf of the company. And also prior to that, we had the Supreme Court had a problem with Telegram because it didn't.
Ah, the secrecy issue, no? I think it's the
Yeah.
secret.
Yes. Exactly.
Yeah.
But it was a problem here was that they changed a lot of times the legal representative and then ended without having anyone because everybody was like really afraid to be
Okay.
arrested just for being like legal representative of
You know
Telegram Brazil.
that the data protection amendment in Argentina that hasn't been approved yet, the bill that was drafted last year, has a provision saying that the legal representative of the foreign company is also liable for the fines of the foreign company. So that's a problem because, let's say I'm a legal representative of a technology platform and they do something and they have a fine of $100 million. I will be liable also as a lawyer for them. And it's very difficult to have legal representatives in Argentina if that is approved. So that's a
Yeah, this is good for insurance companies, especially and
to say that, yeah. Yeah.
they probably love that provision because everybody's gonna need a policy.
I know, I know. Uh,
So
can I
yeah,
tell you a
sorry,
bit
sorry.
about our economic reform that Milei put back? They have like a registry. I mean, they want to promote foreign investment. Because of that, they have a law, Ley Bases, that you mentioned. And in this law, they create a registry for investment that has to be around $200 million. And it includes the technology sector and any sector related with technology of any kind. And if you are able to to start investing this money, you have a protection for 30 years of non-change of the law on taxes, and also you have a exchange and a better exchange regulation for dollars, and you also have a better quota for income tax, and you also have better protection for importing goods from abroad, and you have a protection with arbitration. This is the first time that Argentina does this. That is basically that the company that is investing, if Argentina does not comply with this promise of not changing the law and not affecting the business environment, they can go to arbitration, and the company has the right to choose 3 different regulations for arbitration, which is the ICC, CIADI, this is the World Bank, or the Permanent Court of Arbitration, with specific regulations. And this is at the option of the company.
Very interesting.
Yes,
I didn't know that.
It is in the law. So basically, to take this, the Congress would have to change the law, but it doesn't have retroactive effect. So we're talking of big project here because it's more than $200 million. But the idea is to attract investment and to give legal certainty, because there was no legal certainty for several years. So because of this, they want to make sure that companies coming are not only coming because of the good economic environment, but the promise of not changing the rules. And
Isn't Argentina a signee of the ICSID, the bilateral treaty for investment?
There's a reference to that treaty, and you can use that treaty, and you can also we have a lot of treaties of that. We have several of those, and also the regulation said that you can choose arbitration in Spanish or English, and you can choose to have it in the CH of arbitration can be abroad, and you can use foreign arbitrators and not Argentinian arbitrators. So that's pretty clear that the government is trying to send a signal to the market that they are going to favor protection of investment and foreign companies.
No, I when I read about the Ley Bases, I thought, no, this is really interesting, but I haven't read like the whole document. It's very interesting, this provision related to
Section 220, 221, and 222 of the agreement. So it's, and also it allows the government to negotiate, because usually when there's litigation with the government is not allowed to transact or do a settlement because of public policy, but now it allows the government to transact, do settlements, if it's with a legal opinion saying that this is good for the government, and so that gives a lot of flexibility to the government, because the government itself is allowed to do a settlement and to close things.
In Brazil, we also had this discussion a couple years ago, and now the Attorney General of the IRS, they can also transact. The Attorney General of the Federal Union also can make settlements, but in the end of the day, they are really afraid to give the legal opinion and answer for like improbidade administrativa.
I understand. Maybe it's going to happen here too, because it's but on the paper, on the document, on the law.
Yeah, I hope it works. No, it's very, very interesting. Very interesting. I didn't know about that. So Pablo, we are getting close to the end here. So I would like to ask you to give talk about any challenge for the future. What do you expect? If you wanted to give any tip, feel free. It's the mic is yours.
Okay. No, I think there's a lot coming from Argentina, because if we are able to have a better economic reform amendment and more stable economy, we have a lot of investment, and that will create a lot of work, and probably we have the chance of going back to becoming a very good place for startups and internet companies that used to be in the 90s. So we still need to see whether data protection, for example, is going to be as an added value and not only as a deterrent for innovation. I don't believe that privacy and data protection are options to innovation or non-innovation, because you can have protections of privacy like you have in California, for example, with the CCPA, with innovation. They are not incompatible, but you need to sit down and think about it. But we'll have to wait for 2 or 3 years to see how Argentina develops with this experiment of going back to markets and non-regulation and promoting innovation, to see how it goes.
Okay. Well, Pablo, thank you very much. Every topic that we discussed here, we could spend like
Yeah, I know.
a lot of hours,
I
but
know.
I think it was interesting for those that are watching us, especially for those that doesn't know and want to know more about the legal framework, especially when you're dealing with innovation and technology in Argentina. Pablo is a very accessible person. If you want to know more and talk about and develop any subject to discuss it here, we can follow Pablo in LinkedIn. He's always posting about innovation and developments. This case that he talked about, crypto and the commercial office that they were able to file for the company to incorporate the company with crypto. He posted there. So and thank you for watching us. And next month we'll come back with another subject on technology, dispute resolution, innovation. And thank you, and have a good night, everyone.
Obrigado, Daniel. Chao, chao.
Obrigado, Pablo.
Muito
Gracias.
obrigado. Chao, chao.